Good afternoon. I'll call the order on Thursday, August 22nd at 2024 at 4:30 p.m. The Zoning Board of Appeals. Then I'll take the roll, please.
Sadler,
Here.
Wisner, here, Hecht here, and Kelly and Doran are excused. Legoff has recused himself.
We need to approve the agenda for today. Second.
Make a motion to approve it.
Okay, all in favor? Our next order of business is to approve the July 2024 zoning board of appeals meeting minutes. Do I hear a motion?
I move that we approve the minutes of the last meeting.
I'll second it. All in favor?
And then you also have to approve the related decision documents.
Yes. Now, the second part of that is a motion to approve the decision document.
I move we approve the decision document.
I'll
from our
second it.
previous
All in
meeting.
favor? Okay. The rest of the agenda now, next part of our agenda is Captain's Cottage LLC. That's administrative appeal. A few comments from me first. My name is Tom Sadler, the chair. So I was a part-time village resident in 1988. We built our house in 1994 and been here ever since. Our board members are all village residents of various lengths of time. And how this process works, we get contacted a week and a half, 2 weeks ago, that there will be a Board of Appeals hearing. And that purpose is to collect a date that we can all agree on and have the meeting. The second piece of information we get is that there was a document sent out with the basics of the appeal, that time and date. And other than that, we have no information of what the issue is about or what's happened. In my case, I have no personal information about it. And then 2 days ago, and I thank the attorneys for submitting information early, 2 days ago, I received that information along with my fellow board members and other documentation, in fact, to the tune of 137 pages, which to read and familiarize myself with so that we can have this process today. I now have to, will read, this is the hearing's a little different. Normally the Board of Appeals, we're used to hearing zoning issues on people that want a variance on something that goes on. Then we also hear issues that have to do with rulings of the village administrator or the planning commission or the board of trustees. And that's the years I've been involved in, this is something new today. It fits into our scope of work, but because of that, I will read the following document. This comes from chapter 68, Administrative Appeal. This is a hearing before the Board of Appeals of the Village of Sister Bay upon a chapter 68 administrative appeal as provided by Wisconsin statute. This matter was initiated by an application submitted to the Village of Sister Bay by Adam White, Brigid White, and Captain's Cottage LLC for a short-term rental license under Village of Sister Bay Municipal Code, Chapter 18. Following the submission of that application, there was what was determined to be a denial issued by the village administrator, followed by a request by the applicant for a review of that determination. A decision on the review and determination was issued on behalf of the Village of Sister Bay on July 12, 2024, and is included in the materials that we have today. The applicant has appealed that decision on the review of determination, which is what this hearing before us today is about. At this hearing, the applicant and a representative of the village of Sister Bay may present evidence and witnesses and may cross-examine witnesses of the other party. The zoning board of appeal will listen to sworn witness testimony, review the evidence submitted, and arrive at the final decision, which may occur tonight or be within 20 days of completion of the hearing. That decision may affirm, reverse, or modify the decision on review of a determination and will be supported by reasons for the decision. I note that chapter 68 requires a notice of hearing to be scheduled within 15 days of the notice of appeal, providing at least 10 days notice of this hearing. Is there any objection by either party as to the timing of this hearing?
No.
No.
Okay. Since this is an appeal, we will proceed with the applicant presenting its case first, followed by the opportunity of the village to ask questions. The Board of Appeals members may then ask any question of the applicant's witnesses. The village will then be allowed time to present its position with an opportunity of the applicant to ask questions. The Board of Appeals members may ask their questions next. Finally, the applicant can present any rebuttal information that it chooses to present, followed again by questions of the village and members of the Board's appeal. Are there any questions about the order of presentation?
I have a question. So if we can answer or ask questions of each other, how long is that time frame?
Well, there was none listed here. Well, I will limit it to 3 minutes. Anything else? Okay, then we shall proceed.
We're gonna have to call the hearing to order.
Next, I'll call. The portion of today's meeting, which is the public hearing on this appeal. And this will come to order at, okay. Now we're ready to begin. Mr. Attorney, who's going to speak?
I'll open. So Attorney Bjorn Johnson, local counsel for the appellants here, Adam and Brigid White, who I will also note are in the audience.
Yeah.
We are
Mr.
also,
Johnson, I'd like to make sure that we have sworn testimony today, so will you raise your right hand to be
oh,
sworn?
yeah,
You swear to tell the truth, the whole truth, nothing but the truth, so help you God?
yes.
Thank you.
Okay,
And you'll have to speak up because of where else move up to this table up here.
Attorney Bjorn Johnson, local counsel for the appellants,
Okay,
Adam and Brigid White, who I will also note are present tonight in the audience. I am also joined by Attorney Luke Berg from the Wisconsin Institute for Law and Liberty.
yes.
Attorney Berg will be doing the main part of the argument tonight on behalf of our clients.
Okay,
Good afternoon, members of the Zoning Board of Appeals.
Mr. Bird, can I ask the same thing of you?
Of course,
Will you raise your right hand? Do you swear to tell the truth, the whole truth, nothing but the truth, so help you God?
yes.
Thank you.
So good afternoon, members of the Zoning Board of Appeals. Adam and Brigid White live in Sister Bay full-time, and they own a short-term rental property across the street from their home on the bay side of North Bay Shore Drive at 10775. We are here about the driveway at their short-term rental property. That driveway has been in place, as it is now, for at least 50 years. It has never been an issue until recently. Since this spring, however, the zoning administrator has taken the position that to get a short-term rental license, the Whites have to rip up their driveway, widen it, and move it over 10 feet. Now, before I go further, I'd first like to get everyone up to speed on how we got here today. When the Whites applied for their short-term rental license last spring, they were denied their license on the ground that their driveway doesn't meet the current zoning code. We disagree, but I'll get to that later. The Whites attempted to work through the issue with the administrator, explaining that their driveway is grandfathered, but were unsuccessful. The Whites then tried to appeal to the village board, but they were denied an appeal for failing to pay an appeal fee that, it turns out, didn't actually exist. At that point, they had no other option to file a lawsuit, and that case remains pending at the Door County Circuit Court. The court granted the Whites a temporary injunction to allow them to continue to rent their property and ordered the village to follow the administrative review process and let them appeal. So now that's what we're here doing. We first asked for review by Nate Bell and Randy Nesbitt. They reversed the zoning administrator's denial and granted the Whites their license, but it's still conditioned on them ripping up and replacing their driveway. We've appealed that condition to you, which brings us here today. So what we are asking for here is that you remove the condition and confirm that the Whites can keep and use their driveway that has been there for 50 years. If you do that, the dispute and the case will be over, and the Whites will be able to go on with their lives and continue their short-term rentals on North Bay Shore Drive. Now, before I get to the legal issues, I want to begin by appealing to, I hope, your reasonableness and common sense. The concern here seems to be adequate parking at short-term rentals. Per the current code, that means at least 2 parking spots at a short-term rental. The White's driveway has more than that. It has room for 3, possibly up to 4 cars on it. Let me pause here to note that I have sent you all a copy of these remarks and an appendix of materials that I'll be referencing throughout. In the digital packet that you sent, I think the appendix begins at page 20. But I'm going to be referring to the pages that I put at the top of it. You'll see in the upper right hand of the appendix. So at the beginning of the appendix, if you want to turn there on pages 1 through 5, you can see pictures of the White's driveway. Does everyone see what I'm referring to? On page 6, you can see a survey of their property. So as you can see from the pictures and the survey, their driveway has 2 portions to it. One that is perpendicular to the road and a turnaround that is parallel to it. The pictures show that the turnaround comfortably fits the minivan in just the front half of it, and the vehicle is well outside of the shoulder of the road. The turnaround curves around the utility pole and is farther from the shoulder than the fences on the neighboring properties. So cars parked there in no way interfere with the flow of the traffic along the road. If any car were to veer off the shoulder of the road, it would hit the utility pole or the neighbor's fences before any cars parked in the White's driveway. A few years ago, the Whites put in landscaping next to their driveway, including trees and bushes, as you can see in the pictures, both to beautify the property and in response to discussions with the village about the landscaping requirements in the zoning code. To replace their driveway, they would now have to tear all of that out and would end up paving more of the front of their property, reducing the natural beauty along the shoreline side of the road. That would not be in the best interest of the neighbors or the village as a whole. So in short, forcing them to rip up and replace their driveway and landscaping makes no sense, even from the village's perspective. Now, moving on to the legal issues, a well-established principle of property law is that properties in existence before a change in the zoning code are grandfathered and do not have to update their property to meet the new zoning code. That is reflected in the village's own ordinances and in state law, and it's a constitutional requirement, as the Wisconsin Supreme Court has explained. We've already written about this extensively in our briefing in the case to the Circuit Court, which is in the appendix at pages 7 to 28. That briefing covers the legal issues more thoroughly than I plan to here. Briefly, however, Village Ordinance Section 66.0901 provides that, quote, "The lawful non-conforming use of land which existed at the time of the adoption or amendment of this chapter may be continued, although the use does not conform with the provisions of this chapter." Likewise, Village Ordinance Section 66.0911 provides that, quote, "The use of a structure existing at the time of the adoption or amendment of this chapter may be continued, although the structure's size or location does not conform to the established building setback, height, parking, notably, loading and or access provisions of this chapter." Renting a single-family home on a short-term basis is a permitted use under the village's zoning code for the White's property. That's Village Ordinance Section 66.0311 sub 1A. And nothing in the village's ordinances related to short-term rentals in Chapter 18 provides that merely applying for a short-term rental license invalidates any grandfathered non-conforming aspect of a property. So under the village's ordinances, the driveway is grandfathered and the condition on their license is invalid. But that's not all. State law also establishes that the driveway is grandfathered. Wisconsin statute section 62.23 sub 7H provides that the continued lawful use of a building, premises, structure, or fixture existing at the time of the adoption or amendment of a zoning ordinance may not be prohibited, although the use does not conform with the provisions of the ordinance. There are only two exceptions to this, neither of which apply if the use is discontinued for 12 months or repairs and alterations exceed 50% of the assessed value. As you know, state law trumps village ordinances, so even if the village's ordinance did not provide grandfathering protection, state law clearly does. Finally, the Wisconsin Supreme Court has held that grandfathering is required by the Wisconsin Constitution. We cite a bunch of cases in our brief at appendix pages 19 to 21, but to quote just one of them, quote, "Zoning regulations cannot be made retroactive, and neither can prior non-conforming uses be removed, nor existing conditions be affected thereby." That's a case called Desjardins, I'm not sure how to pronounce it, but it's in the written remarks. So the basic point of all of this is that the White's driveway is grandfathered. They can keep it and they can continue to use it. The village cannot use the annual short-term rental licensing process to do indirectly what it cannot do directly, eliminate the grandfathered aspects of a property. Now, evidence that the driveway has been in place for at least 50 years is found in the appendix at pages 29 to 30 in a declaration from Kevin Wolt, one of the prior owners of the property. As he explains, he lived there in the 1970s when he was in high school. The driveway was the same then as it is today, and it hasn't changed since to his knowledge. Furthermore, as I explained in the declaration at page 31, I attempted to obtain the permit for the original driveway from the Wisconsin Department of Transportation. They were unable to find it in their records, but explained to me that their electronic records only go back to the 1980s. So it's very possible the permit is in a physical logbook somewhere that is apparently much harder to search, or the driveway might have even predated the permitting process. All of the village's zoning requirements related to driveways were put in place well after the White's driveway, as we discussed at length in our brief in the appendix at page 11. So for that reason alone, the condition on the White's license is unlawful and should be removed. Our hope is to resolve this here and now, but if the village persists in requiring them to replace their driveway, we are fully prepared to litigate this all the way up to the Wisconsin Supreme Court if necessary. Now, moving on from the grandfathering issue, even putting that aside, the White's driveway does conform to the current zoning requirements with one minor exception. The only current requirement that the White's driveway does not meet is the 10-foot setback from the neighboring lot line. But there is no evidence that the neighbor has complained about this. As the picture shows, there is a thick line of trees and bushes at the edge of the driveway to separate the lots. Setback requirements are the paradigm example of why the grandfathering rule exists. It makes no sense and frankly would be unjust to require property owners to tear out and reconstruct their driveways just to move them over a few feet when a setback rule changes. Even if the Whites are not grandfathered from the setback requirement, This board is uniquely in the position to grant the variance from the setback requirement as another potential way to resolve the dispute, and it should do so if it thinks necessary. Other than the setback requirement, the White's driveway does comply with all of the other requirements in the current zoning code, which makes this an especially silly fight for the village to dig its heels on. Now, there's one other potential issue related to the right-of-way that the zoning administrator has raised, so I'm going to spend the rest of my remarks on that. It takes some explaining though, so bear with me. The phrase right-of-way is not always used consistently, but for purposes of our discussion now, it refers to a 66-foot wide strip of land that follows the road. This is not the actual width of the road. The actual width by our measurements, including the shoulder on both sides, is roughly 37 feet. Instead, this is the land that the state can potentially use if it ever wants to expand the road, widen the shoulder, etc. That potential 66-foot strip extends 10 to 15 feet beyond the actual paved shoulder of the road into the lots along Bay Shore Drive. The position that the zoning administrator has been taking is that cars cannot be parked anywhere in that potential 66-foot strip, even on one's own driveway that is outside the actual shoulder of the road. Applying this to the White's property, the turnaround portion of their driveway is largely within that unused portion of the 66-foot potential right-of-way. So the zoning administrator's argument has been that they can't park any cars there, even though it's their own driveway, and therefore they only have one spot, and that's not enough parking. Now, there are multiple problems with this interpretation. The first and simplest, however, is that it's inconsistent with the text of the village's own ordinances. In the village's parking ordinance, section 66.0405, the very first subsection, 1A, says, quote, "Vehicles that do not exceed 12,000 pounds may be parked on a driveway." That's pretty straightforward and resolves the issue to my mind. It's a clear authorization to park on a driveway. The section the zoning administrator is invoking is two subsections later, subsection 1C. It says that vehicles must be located outside of all ultimate right-of-ways. But a basic rule of legal interpretation that courts regularly apply is that the specific trumps the general. So the specific authorization in 1A that you can park on driveways would trump any interpretation of 1C that you can't park on the portion of your own driveway that happens to be within this potential but unused portion of the 66-foot strip. Second, if this is really how the village's parking ordinance works, the village would have to apply this prohibition equally to all properties within residential districts, not just short-term rentals. On Bay Shore Drive, that would mean no one can park their cars in the first 10 to 15 feet of their own driveway. That would also mean each of you, if you live in the village, cannot park any cars at the end of your own driveway. How far up your driveway depends on some hypothetical right-of-way that is hard to find and determine. The village clearly is not actually applying the ordinance in this way. In one of the pictures I took of the White's turnaround, you can see that the neighbor has a car parked at the end of their driveway. And as I pointed out earlier, and you can see in the pictures, both adjacent properties have fences within this potential but unused portion of the right-of-way. I would also add that when I arrived here, 3 hours before this meeting, I drove around the village and took pictures of about 15 to 20 examples of cars parked at the end of their driveway, right next to the edge of the road, presumably in the right-of-way. None of them had tickets, none of them had been towed. I can provide those pictures if the board would like. Third, and perhaps most fundamentally, it is not clear at all that the village even has jurisdiction over the White's driveway and where they can and cannot park on. As you well know, North Bay Shore Drive is a state trunk highway, Highway 42, and has been for at least 100 years. In page 33 of our appendix, we include an order from 1928 from the Department of Transportation renaming the road and relocating. So you can see it's been owned by the state for a very long time. It is owned and maintained by the state, not the village. Most importantly, driveway permitting is controlled by the state Department of Transportation rather than the village, pursuant to Wisconsin statute 86.07 sub 2 and Wisconsin Administrative Code Transportation Chapter 233. That means that the permit and the permission for the driveway came from the state And it is the state's responsibility to police and maintain the safety and traffic flow of the road. Now, the Department of Transportation has a manual for how it deals with old driveways like the Whites, which have long been in place and where the permit cannot be found. This manual is in the appendix that we sent you at pages 33 to 35. According to the manual, such driveways are treated as a legal non-conforming use. You can see that in the table at page 35 of the appendix. Moreover, the manual says specifically, quote, "Do not compel an owner to bring a non-conforming connection driveway into compliance or remove it unless a safety or operational problem warrants the action." That's on page 37 of the appendix. And again, because it's a state trunk highway, it's for the Department of Transportation, not the village, to determine whether a safety or operational problem requires removal of an old driveway. There is no evidence that parking in the turnaround is a safety issue. Again, there are utility poles and neighbors' fences closer to the road than cars parked in the turnaround. There is also a separate, well-established rule of property law in Wisconsin called the center of street rule. The basic idea is that property owners abutting a road own the land under the road all the way to the center of the street. The rule applies even where the conveyance names the highway as the boundary of the parcel conveyed, quote from the case. That ownership interest is subject to the public right of way, of course, but it's a joint ownership interest. Wisconsin courts have repeatedly articulated this principle. And if you look at my prepared remarks, we've cited a bunch of cases in footnote 2. One of the corollary rights to the center of street rule is that, quote, "The owners of the land underlying a highway and the right of way have the right to use this land in any way that does not interfere with the rights of the public." That's a case called Geiso from the Wisconsin Court of Appeals. And remember, the part of the potential right of way that we're talking about is the unused portion. So to put this all together, the state, not the village, controls the 66-foot potential right of way, including any unused portion. The Whites have permission from the state for their driveway, either by a permit or as a legal non-conforming driveway. And as abutting property owners, they have a right to use the unused portion in any way that doesn't interfere with the road. Parking on the turnaround clearly does not. If it does at any point, it's for the state to address it, not the village. So for all these reasons, we would urge the board to remove the condition on their license, and we'd be happy to answer any questions that the members of the board have. Thank you.
Before any members of the board have questions, we'll ask the village administrator, does she have any questions or rebuttal?
Sure, I just have a few. So your evidence that the driveway was there for 50 years is solely based on the declaration from the man who sold the property, right?
And my declaration as well.
Do you have any factual documentation on the existence of it, other than statements?
I think declarations are competent evidence in a court of law, so I think they're competent evidence here.
So, and then just real quick, you had said that the Whites had conversations a couple of years ago with the village regarding landscaping, by their driveway. Do you know when that was with?
I don't.
Okay. And then you had said, you have evidence that the driveway complies with everything except the 10-foot setback. What is the other stuff that it complied with?
Well, I think it's on the village to tell the Whites how it doesn't comply. And part of the problem throughout this process, they have repeatedly asked for how their driveway doesn't comply with the existing code and haven't gotten an answer. The answer that they got was largely the 10-foot setback. And then this position that they don't actually have 2 parking spaces, which seems to be premised on this idea that they cannot use the majority of their driveway because it's in this potential right of way, the unused portion of the right of way. I think that's wrong for all the reasons that I've explained. So if they can park on that portion of their driveway, they clearly have enough spots. The size of the spots meets all of the width and length requirements. You can see the dimensions of the driveway in the pictures we've submitted. So I reviewed all the requirements and I can't see any other requirement that their driveway doesn't meet.
Okay, I was just asking, because you said the evidence is that it complies with everything except 10, so I was just wondering if you had evidence.
Yeah, I would say the pictures that we submitted that show the dimensions of the driveway.
One more question, if I still have time. Could you tell me when I said they could not park at the end of their driveway or in the strip?
It's in an email that you sent me that is in the appendix.
That's exactly what it said. Thank you.
Do any members of the board have any questions?
I'd like to know when the property was purchased.
Fall 2020.
And was it purchased from someone who used it as a short-term rental or who lived there?
Their mother lived there, and then once the house passed to to the children of the owner, they rented it for a few weeks before selling it to us.
So you bought the house in 2024,
2020.
2020, I beg your pardon, and your mother lived there for part of the time from 2020 onward?
The Wolf family, mother owned the house for her husband. She passed away. The Wolf children took ownership of the home and rented it for 2 to 3 seasons before we bought it.
I'm having trouble hearing, understanding you.
So we bought it from the Wolf family. Their mom and her husband lived there for years. They own Johnny's Diner downtown. And the kids grew up there. So when she passed away, the house went to the kids and they weren't sure what to do with it. So they rented it out for about 3 years. And then they decided to sell it and sold it to us. And then we actually took on some of their rentals so they wouldn't have to cancel any. So it's been rented out for years.
Point of order. I thought that the only one that was gonna be able to give testimony was Mr. Berger and myself.
I think they're able to answer questions. They were here to answer questions.
I was asking counsel.
If the chairman wants to allow them to answer questions, he could do that. If you'd like to have them sworn, we could do that also, Mr. Chairman.
Well, let's do that since they have been talking.
Okay. Mr. and Mrs. White, would you raise your right hand? You swear to tell the truth, the whole truth, nothing but the truth, so help you God?
Yeah.
Thank you.
If the attorney couldn't provide that information and they could, I find it useful for this hearing. Any other questions?
No.
Liz? How many bedrooms are there in the rental property?
4.
I know in the July rules by the village where there's 4 is maximum number of bedrooms that can be used for rental. And it's then sort of based at up to 4 parking spots would be available for use by the renters. So, on the basis of what you have said so far, you have met that with the property that's there and using it in the way that it's been used. So, if I understand correctly, this property, the rentals began in 21 by the Whites?
In 20, I think when they bought the property, they immediately started renting it on a short-term basis. It had been rented on a short-term basis for 3 years by the prior.
Right, but they have been renting it continuously since 2020.
Yes.
Okay, fine. I have no further question.
Mr. Chairman, if I may, I want to just do something to clarify the record. Would that be acceptable?
Sure.
Okay. And my role, Mr. Berg, is, as you're more than likely aware, is just to make sure we have a clear record and that everyone here on both sides has due process. But one of the things that was entered in your presentation was the affidavit of Mr. Wolt, who said that the parking area had remained in its present condition for at least 50 years, since at least 1976. And I look at Exhibit 1, the picture of that circular parking area around the telephone pole. And I'm wondering if that was there that entire time, based upon I think it's Appendix 6, the survey from 2011 that does not make any reference to that parking area. So I'd just like to clarify that point, if you will.
Yeah, you can actually see it on the survey. So if you look on the survey, this is page 6 of our appendix, you see the black area is the house. You see this kind of dotted line coming out. It says overhead utilities. Goes to a little circle. That is the utility pole. And then you can see around it is sort of a dotted shaded area that represents the turn.
So that has been there, as far as you know, since back in the 1970s.
As far as we've been able to determine.
Thank you.
Mr. Chairman, I have one more question, please.
Sure. It's our back.
Is the rental property the only building on, the rental unit, the only building on the property?
Yes,
It is. There's no garage
correct,
or sheds
correct, yeah,
or,
correct. No garage, no shed.
thank you.
Anything else? Anything else, Patricia?
No, thank you. I'm on page 793. I'm getting there.
Okay, we will hear now from the village administrator.
Okay, I will address the specific reason for appeal, which we are here to discuss, which the appellant identified as the condition on the White's short-term rental license requiring their parking be brought into compliance with the municipal code. Before I begin, however, I'd like to remind the Board of Appeals that contrary to Mr. Berg's written request to your reasonableness and common sense, which is on page 1 of his letter, you are tasked with a factual analysis. Your review is to be based on the facts, and you should not be replacing your determination on whether something in your judgment is reasonable or personally makes sense on the facts presented before you. Also, I have not included the short-term rental code as an appendix, and that it is my understanding it was provided to you with the agenda and Mr. Berg's written appeal. So you do have a copy of my rebuttal along with my appendixes on your tables, and I will go through them. I won't read all the appendix in detail for the sake of brevity, but we'll reference them. So first, I'd like to start with the code history to help us understand, like Mr. Berg did, how we got here. Wisconsin statute 61.35 gives villages the right to plan for the development of their communities. Wisconsin statute 62.23 lays out the process for municipal planning. As you may recall, the controversial smart growth law enacted in 1999 required municipalities to develop 20-year plans to guide their land use decisions. The law then required the plans to be consistent with local zoning ordinances or risk losing state funding. The village of Sister Bay is in the process of updating our comprehensive plan, but still operates under the 2000. Yes, sir.
Can I stop you for a moment because I forgot to swear you in? Do you swear to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you.
We are in the process of updating our comprehensive plan, but we do operate under still do operate under the 2003 plan and subsequent zoning. Our smart growth plan adopted in 2003, chapter 3, had to address housing, and sadly back then we faced some of the same issues we face today on affordability and quantity of workforce housing. Chapter 8 addressed land use, indicating a need for residential development that should be buffered from traffic noise and incompatible uses. At the time the plan was adopted, transient use was considered a commercial activity. And policy 2 of the commercial objective in the land use strategy was points of vehicle ingress and egress should be properly located and controlled to prevent safety problems and traffic congestion on adjacent arterial streets. It seems that even in 2003, the village understood commercial type activity would require managed access onto the highway system, and development in residential areas would need to address traffic, noise, and incompatible uses as well. Subsequently, and required by the smart growth legislation, we had to adopt a zoning code. Fortunate for Sister Bay, we had adopted our first zoning ordinance in 1964. It was an interim code, followed by a comprehensive zoning code and official zoning map dated November 13th, 1973. We have been very responsive to the public's concerns and interests, and since that adoption date, we have reviewed and updated our zoning code several times a year. The zoning code, up until recently, which I'll address later, did not allow homes to be rented on a commercial transient basis. And even in 2004, the year after the smart growth plan was adopted, did not allow homes in a residential district to be rented on a commercial transient basis. This was not allowed legally in the village until 2022. Through sound planning and zoning, the village was able to control growth and development, minimize land use conflicts, and preserve the character of their residential zoning districts and neighborhoods. However, it appeared that in 2017, the very state that mandated municipalities to plan and follow those plans took away the right of municipalities to implement those plans consistent with state law and the municipality's intent. We were denied implementing our own mandated plans. Via Act 59, effective 2018, a municipality could no longer enact or enforce an ordinance that prohibited the rental of a residential dwelling for 7 consecutive days or more. And if there was an ordinance in effect that was inconsistent, as of September 23rd, 2017, it didn't apply and could not be enforced. We could, however, adopt ordinances regulating the rental of a residential dwelling in a manner that was not inconsistent with the regulations just mentioned. And the accompanying statutes, which were 66.1014, which is attached, required the operator of a short-term rental to get a license if the local ordinance required it. Again, in 2017, we did not require that because we were not allowing the rental of the legal rental of single-family dwellings. To be clear, though, again, the village should not allow people to rent their homes on a transient basis. So anything before that date was not grandfathered. It was a flat-out violation. With Act 59, the village saw an increase in rentals. As of 2017, when the state prohibited us from regulating short-term rentals, except as written in the act, the Door County Tourism Zone Commission, which monitors the room tax reports, showed we had 40 single-family homes that were likely in violation, but being rented. We know that there were cottage resorts, those were grandfathered legally. Multiple occupancy developments, cottage resorts were treated different than the rental of just a single-family home. As the village saw an increase in rentals and associated complaints, they decided to require a short-term rental license. Their first ordinance became effective for the July 1, 2022 to June 30th, 2023 licensing period and attracted more rental operators. There was approximately 106 applications that first year. It became a processing nightmare. Net 88 of those 106 applications were deemed incomplete. It appeared applicants didn't invest the time to complete the forms or submit the addendums. It also resulted in an influx of transients in residential neighborhoods and a multitude of complaints. Of the 106 applications, 42 of the applicants had at least one violation, and 27 were missing parking information on the application or had parking violations. cars parked on grass or on the street were common complaints that year. It appeared many single-family dwellings were not being rented as single-family homes, but as lodges of sorts with a large number of guests and sometimes a need for commercial-sized parking lots. In 2022, when we started licensing the short-term rentals, Sister Bay had the highest increase in room tax collections. We were booming. By 2023, what we saw in all of 22, we saw it in just the first few months of 2023. Although grateful for the dollars, it meant an explosion of rentals. And it showed by the volumes of complaints we were receiving. We also were noticing inconsistencies on applications and that we were what we were seeing in the field. It seems some applicants were either intentionally or unintentionally submitting false information with their application. After adoption, though, the village also realized the short-term rental code conflicted with their zoning code, chapter 66 of the municipal code, which did not allow short-term rentals in all districts. So in 2023, the Plan Commission and the Village Board held numerous meetings and public hearings in 2023, trying to resolve the land use conflicts and issues being raised. They proposed several solutions, and some were greatly opposed, but what they came up with in the spring of 2023 was something the trustees felt was a good compromise and something everyone could live with. And it seemed to work. Complaints dropped drastically. One item they required to address parking concerns was that the applicant had to show the actual dimensions and location of the parking, which became very telling as to whether there truly was adequate and code compliant parking on site. Next, I'll talk about the White's applications. The relevant pages are in your appendix. The first license that the Whites had was license number 22-010. White applied for the short-term rental license on May 9th, 2022. Chapter 18, as of the application date, required sufficient off-street parking shall be available to accommodate all vehicles on short-term rental premises. And again, the key is it had to be off-street parking and it had to be on the short-term rental premises. Off-street parking shall comply with the Sister Bay zoning code, section 400 is how the code read. On-street parking for renters of the residential dwelling is prohibited. Again, it said on-street parking for the renters of the residential dwelling is prohibited. Also, in regard to parking, the applicant's property rules and web listings had to include information about the maximum number of off-street parking spaces. Those rules also needed to include a diagram of the location of the off-street parking. In 2022, Mr. White didn't challenge, question, or appeal the requirement his parking had to meet the requirements of the zoning code. White signed his short-term rental license application on May 3rd, 2022, certifying the information was true, accurate, and complete, and that a failure to comply with Chapter 18, which required compliance with zoning, could result in license suspension, revocation, non-renewal, and penalties. The village clerk reviewed the application, saw he provided a plan, and his rules identified there were 3 stalls and approximately where the parking was located. He did not supply dimensions, they were not required at that time. And she therefore issued the license on May 12th, 2022. Then there was license number 23048. White submits an application on May 17th, 2023. At that time, Chapter 18 basically read the same in regard to the licensing of short-term rentals. White again signs the form, verifying the accuracy and truth, and where the form requests information about the minimum number of off-street parking stalls, he lists 3. He submits a copy of an old survey, but no parking plan, but he did certify he had a minimum of 3 off-street parking stalls that he certified complied with the zoning code. So the license was issued. In an email to Mr. White, from me to Mr. White dated May 19th, 2023, as part of the application, and it's in your appendix, I advised Mr. White that staff was quickly trying to issue his license before the May 20 deadline and advised him the rules could change the next year and that his property was not inspected for violations. And he is told, and I quote, "The issuance of the license does not void the need for you to continue to comply with municipal codes." He is also reminded there is no parking on the grass, street, or in the right-of-way. White accepts the license and does not appeal the code, decision, or information in the email. Just a side note, not related to that, but after numerous complaints about the proliferation of cars parking on the streets, grass, and driveways in the residential zoning districts, challenges with people not accurately depicting how much and where their parking was located, and people certifying compliance with section 400 in the zoning code where the property was in fact not in compliance, chapter 18 was revised in 2023. It added more regulation, but spelled out the application requirements in detail to try and minimize the number of incomplete applications that we were receiving. The zoning code was also revised, in part to make it explicitly clear that a home, whether rented as a short-term rental or not, needed a minimum of 2 code-compliant stalls, but not more than 4 for the property if you were short-term rental. Requiring 2 stalls for a dwelling was not a new requirement, nor were the parking design standards. After those new rules were adopted in 2023, on March 18th, 2024, Mr. White applies for short-term rental license, which is the one where the subject of the appeal. He is missing data, and staff is concerned with some of the information he provided. He was missing information on the application form, had the wrong address on the application, his inspection report was outdated. I think his wife forgot to sign the application, if I remember correctly. His DACAP license was expired, and we questioned him if the deck was new, which it was not. His house rules needed to clear some information about his garbage, and the rules were incomplete. In addition, he was told in an email dated April 23rd, 2024, "The most significant issue is your parking situation. You must be able to provide at least 2, but not more than 4 legal parking stalls. Legal means each stall is 10 foot by 20 feet, asphalt, out of the right of way, and at least 10 feet from the neighboring lot line. The driveway must be at least 10 feet, but not more than 24 feet. Your plan shows 1 stall north of the home, adjacent to the road, but an inspection revealed no true parking stall asphalt area, and if it did exist, it doesn't meet setbacks. You also show what I call a pullover parking in the public right-of-way, which is not allowed, and the asphalt must be removed from the public right-of-way." And that's in your packet. So I did tell Mr. White exactly what was required to have a full compliant parking area. He was not denied a license, rather he was told what he needed to do to get the license. Mr. White responds that same day. "We have many parking spots we can share with renters on the new driveway across the street from the cottage. It will be poured concrete and completed in a couple of weeks. I noticed in the regulations you need a signed agreement with the one providing the shared space. Will you need me to sign for myself, or should I just document on the new site plan? I've made a note of your other items on here and we'll take care of them as well." I respond on April 25th. "Adam, we don't allow you to use parking off-site. The code says the parking has to be on the same lot. We do allow shared driveways, but your situation wouldn't be considered a shared driveway. Hope that helps." Adam also responded April 25th, addressing the other issues and concerns. Some of the required information was later submitted via his attorney. And Mr. White and I subsequently set up a meeting, date and time to discuss his parking. Actually, I think I might have set it up with his wife, I can't recall. I have to look in the notes. White's attorney, Bjorn Johnson, then contacts me, copies White, and Johnson is informed the Whites have appeal rights. Mr. White had been very cooperative. I felt easy to work with. It was via email, but then Mr. Johnson contacted us. And I did tell him if they disagreed with everything, he did have appeal rights. In the email, I let Mr. White know that since he employed an attorney, I would not be able to meet with him again. Or not be able to, not again, I wouldn't be able to meet with him. On May 8th, Mr. White submits a plan for a new driveway. He indicates the existing asphalt would be removed and replaced with grass and flower beds. That was actually the first time I saw an email regarding landscaping at Mr. White's property. And the new driveway would be poured concrete. On May 22nd, I write White explaining, if I understand his plan correctly, it will meet code. But I ask him to verify my understanding of the plan is correct. White doesn't respond, but his attorney does, and instructs me to not contact the Whites without his presence. So there was one allegation that I just stopped talking to the Whites. Well, I was told I couldn't talk to the Whites without the attorney present. And that's documented in the file, as you'll see. There was no further contact with the Whites after that day. Johnson submits an appeal, and as you know, he did not follow the process outlined in the code. I'm sure you saw that from the documentation that was submitted. The village attorney, Randy Nesbitt, writes Johnson explaining he did not appeal following the process outlined in chapter 18. Said he had followed a process outlined in the statutes. We argued chapter 18 trumped that. And the appeal was not made within the 30-day time frame. Johnson then argues he didn't appeal via chapter 18 because the village failed to create a fee for the appeal. Yet no village staff have recollection or evidence of Johnson even inquiring about the fee. It appeared he had just appealed under the wrong section and then later said he didn't use the village code appeal section because he didn't know what the fee was. It didn't matter though. It went to the circuit court and it got remanded back. Next, I'm going to talk about Mr. Burke's argument that the existing driveway is grandfathered. First, the zoning code doesn't grandfather driveways for short-term rentals. Grandfather isn't a term we use, it's legal non-conforming is the correct term. So when I say grandfather, or when Mr. Burke does, we use it or I at least use it interchangeably for legal non-conforming. So our code does say that if you are a short-term rental, we are not going to grandfather an illegal driveway. And I'll get to that. However, if the code did grandfather the driveways, this driveway is not a grandfathered legal non-conforming driveway. I'll talk about that. Secondly, if Attorney Berg believes the driveway or driveways are legally non-conforming, he must prove it. Simply saying something is grandfathered doesn't make it grandfathered. Chapter 66 requires the burden of proof as to a use's non-conformity to be on the applicant. Specifically, section 66.0901, parent 3 parent reads, the owners of property claiming to have a legal non-conforming use or a lawful conditional use have the burden to prove that such use was in fact a non-conforming use or lawful conditional use in accordance with section 66.0922 of this chapter. Again, it's a zoning code. As mentioned earlier, the village ordinance was adopted on November 13th, 1973. The one I just mentioned is our current code, but we originally adopted comprehensive zoning, November of 1973. The ordinance required any home erected or placed on a lot to have one parking stall. Clearly, anyone before that time absent a driveway would be grandfathered. This home was built in 1946 and therefore it predated the adoption of zoning in 1973. And on the face would not have to have a driveway. The lack of a driveway is therefore a nonconformity on the lot. As Attorney Burke stated, the driveway is allegedly nonconforming, and I'm saying allegedly, he's saying it's nonconforming, and can continue in perpetuity until it is all altered. However, we disagree that it was nonconforming, that driveway was there in its current condition prior to November 13th, 1973, when the village adopted zoning. In 1974, public water was installed in the village. In that year, water was installed along North Bayshore Drive. The as-built plans from the public utility documents are in your packet, Appendix 3-B. The village installed the curb stops in the years that followed, which is the connection from the lateral to the home, as shown in Appendix 3C. Per utility staff, we never install a curb stop under a driveway. It would be cost prohibitive to dig up a driveway, put in your curb stop, which is basically you have the lateral going down the road, then you have the lateral going into the property. We would never put that under a driveway. We would have to pay for asphalt driveways, concrete driveways. Instead, they go in grassy areas. So based on Appendix 3C, and 3B and 3C, we know that as of that date in 1974, there was no driveway, at least along on the property. Now, I'm not commenting about what's off the property in the public right-of-way, but as far as that stall along the north property line, it was not there when the laterals and the curb stop went in 1974, which was a year after we adopted zoning. Then there was a survey done by Lee Telfer in November 11th, 1977. The property had no driveway as of that date either. The survey that was submitted by Mr. Berg is a more recent, it's not recent, it's more recent, and it showed like a stone wall kind of around what the parking that's there now. That stone wall is not on the Telfer survey, and the Telfer survey does not show a driveway there. Mr. Telfer was very detailed, and there's a lot of detail on that survey, but there was no driveway on that survey, November 11th, 1977. Evidence indicates the property had no driveway prior to that survey. The driveway or lack thereof was, as Attorney Burke told us, non-conforming. The code in effect, when the driveway or lack thereof became non-conforming, read. Okay, so remember, zoning 73, no driveway there, it went in after that. But as of 1973, the way the code read regarding nonconformities was the lawful non-conforming use of a structure, in other words, something that's there, existing at the time of the adoption or amendment of this ordinance may be continued, although the uses do not conform to this ordinance. However, it goes on to say, however, structural alterations, only that portion of the land or water in actual use may be so continued, except when required to do so by law or order, or so as to comply with the provisions of this ordinance. That 1973 went on to say, there shall be no more than one access and one exit driveway to streets and highways. The maximum width is 24 feet for the driveway. Around 1978, the previous owner remodeled the home, and per a letter he wrote opposing his neighbor's petition for variance in 1979, we know that he took out a permit. The plans, I think, were 1976, but in a letter opposing this petition for variance, he said he built his addition the previous year, which would have put it at 1978. We thought that maybe the driveway was installed at that time. And that makes sense with the statement that Mr. Berg had. It was, you know, would make sense that it was in that mid-70s. Although the permit in the file doesn't show a driveway nor do his assessment records. In 1983, the code was rewritten. And it was amended to require a dwelling to have 2 parking stalls. So 73, you get zoning, says you need 1, there's no driveway or anything. In 83, we change it to say 2, there's still no proof there's a driveway on any surveys or anything. But now you needed 2, as of 1983. In 1997, the adjacent neighbor to the north had a survey done. And if you look at that survey, it shows all the encroachments. It's very detailed. It's showing how the neighbor to the north is encroaching on them. It's showing all the encroachments. When you look at the south property line, which is Mr. White's property, there's nothing. That stone wall, that one, that now goes right up to the property line, that wasn't on that 1997 survey. Maybe it was there, but just not on the survey. But it's not on the survey. The assessment record from August 21st, 1998 does show an asphalt driveway. It shows an asphalt driveway, so we know by 1998, there was an asphalt driveway somewhere on that property. Could have been there before that, but that's when we were first seeing it on the assessment records. It shows an asphalt driveway of 1,098 square feet, which appears to be the asphalt in the right of way. Because the one on the north property line is only 200 square feet. So it was showing it was being assessed for a much larger asphalt area. This is also when we see a significant jump in the assessment record reflecting a previous remodel and addition that Mr. Weiss, I think, how you pronounce it, had done that year, or the previous year. We tried to get historical air photos to see what was going on there, but the county stopped posting the historical ones out there. So the first one we have access to is from 2007. That air photo does show what appears to be an asphalt driveway asphalt driveways as they currently exist right now. It is clear the parking and driveway situation lost its legal nonconformity and was not brought into compliance. It is therefore a violation. There was no driveway there. There was something put in after zoning was adopted that did not meet code. That's called a violation. That 1973 code did have another requirement that said no vehicle shall be parked within 10 feet of the street line, which is kind of what Mr. Berg was alluding to. You know, he said that, he said he couldn't park at the end of the driveway. I've never said that, and the documents show that. What I said is the code requires you to make sure you have enough room on your lot for these legal stalls. So you have to make sure you can legally fit a car on your lot. Now, if somebody parks over that or beyond that, you know, we're not out there measuring it. The code doesn't even, the current code doesn't even say you can't do that. What it says is you have to have enough room on your lot to have code compliant stalls. If you extend beyond that in your driveway, so be it. I've never said you can park at the end of your driveway, and the code doesn't either. But coincidentally, the old code did. The old code did say you cannot park within 10 feet of the street line. Since there was no driveway or parking spaces whatsoever in the village adopted zoning, when the parking and driveway were to be installed, they would have had to meet code. Furthermore, since the parking and driveway are not legal non-conforming, meaning they're not grandfathered, and since the municipal code, chapter 2 administration, which is the very beginning of all our municipal codes, it's not in zoning, it's not in short-term rental, but it's in the very beginning that says, this is how this village will operate. That code, chapter 2, says we cannot issue a license. Short-term rental license, dog license, liquor license. We cannot issue a license if there are alleged violations in dispute or proven to be among municipal code violation. Staff feels like should not even have received the license. But he did, we did it to move a case along. But as you know, there's the condition that he has to bring the parking into compliance. As indicated earlier, we were forced to issue a license and put the condition on. But it's important to realize the short-term license is a license, it's not a permit. Which means every applicant must comply with the rules in effect at the time of application. Again, being an annual license, yes, get it every year. The applicant must comply with the rules in effect at the time the application is deemed complete. On March 18th, 2024, when the Whites applied for their annual short-term rental license, even though it was not a complete application, the codes required a short-term rental to have a minimum of 2, but not more than 4 code-compliant parking stalls. Code still says that, right? It's only been a couple months. So what is code compliant? I have all the regulations in here. These regulations were also shared with Attorney Berg a couple months ago. And they're the same ones, or very similar ones, which I had shared with Mr. White. I told Mr. White exactly what he needed. This goes into the detail of what all those residential parking codes are. For example, it is true. You can park a 1,200-pound vehicle on your driveway. But you don't just look at that section and it's wrong. That does not trump another section. You have to look at it in totality, everything that applies to a residential zoning district. You can't pick and choose one section over the other. In totality, what is required or allowed for a residential zoning district? All of that is included in your packet. Let me solve here. So simply code compliant stalls must be 10 feet wide, 19 feet deep. We run them off a lot of times when we're talking, people say 20, but it is 19 if you look at the actual angle chart. They have to be on site and outside a public right of way and 10 feet from a property line. Dwellings in a single family resident zoning district are allowed one such driveway, not to exceed 24 feet in width. We also have sections in here that says if you have a U-shaped driveway, entrance and an exit, which this technically is, but it's not on its property, so it doesn't really apply. But if you have that, that would not be allowed in certain cases. There's sections in the code that say how to bring that into compliance as well. Lest we not forget, the non-conforming use section of the code also requires, I'm going to quote here, existing benign non-conforming structures, meaning a non-conformity that's not causing a great deal of damage, but the definitions in the code, if we'll look at it, which are remodeled or reconstructed, shall conform to the established building setbacks, height, parking, loading, and access provisions in this ordinance. The home on the lot is a non-conforming structure because it does not meet the required road setback. And Mr. White has remodeled the home. I actually have the permits in front of me that he submitted. And they specifically say remodel kitchen, remodel bathroom. That was in 2021. So the code says if you have a non-conforming house, the house doesn't meet setbacks, which this did not, and you remodel it, the code is very clear. You have to bring it into compliance with parking. That section is in your packet. Next, I'd like to talk about, does the village have any jurisdiction over Highway 42? Because Mr. Berg says we have no authority to control the asphalt that is in the public right-of-way on Highway 42. We realize that Mr. White did not put that asphalt there. We can tell by the 2007 air photo, he did not put that there. Nonetheless, it's not on his platted lot, and it is in the public right-of-way of State Highway 42, known as Bay Shore Drive. You have a copy of the original plat, which shows that platted roadway and the size of the platted lot anyone would like to see it. The Wisconsin Department of Administration manual that Mr. Berg references, he says it supersedes village authority. That doesn't apply in this case. Wisconsin statutes 349.13 gives the village authority to enact ordinances related in respect to highways, even if they're state highways, under their jurisdiction. So the question becomes, is that highway under village jurisdiction? The village entered into a state municipal maintenance agreement on October 17, 2018 for that portion of Highway 42 north of Scandia Road up into Gills Rock, which is where this property is located. That agreement states, the agreement we had to sign with the Department of Transportation says, the municipality agrees to, quote, regulate parking along the highway, end quote. We know a property owner installed the asphalt parking area. We talked about that between 1977 and 2007. The parking area is used by guests staying overnight at the short-term rental. As allowed by the Department of Transportation's agreement, we adopted a municipal code which says they can't park overnight on that street. And we have every authority. The DOT gave us the authority. The statutes give us the authority. So we have and have had chapter 58, just like chapter 66, just like chapter 18, we have a chapter called chapter 58, traffic and vehicles. And it says, well, first of all, it says you can't park anything in excess of 22 feet out there along the highway. But it also says it prohibits overnight parking on the same road or on that road. Overnight parking is between 2 a.m. and 7 a.m. Well, if you have a short-term rental and you've got one non-conforming or illegal stall, you know, it doesn't meet code, and you can't park on the grass, and you can't park overnight on a street, and oh, by the way, the asphalt area you're using is in the public street or on the public right of way, where are you gonna park? You're not. You're gonna have to violate the code. Do we start going out there and giving every guest of Mr. White's a ticket? Do we start towing their vehicles? Nobody wants to do that. And that is why when the village was looking at codes, they said, we gotta make sure you've got enough room on your property for your guests. And that's why they put the code out there. They said you have to have at least 2. But we also want to make sure these don't turn into lodges or big commercial areas. So we're going to cap it at 4 pure short-term rental. Like I said, that number 2, that's been on the books a long time. That number 2 was on the books before that driveway was put in. That number 2, that you had to have 2 on site, that was put in when Mr. White remodeled, but before Mr. White remodeled his home to that non-conforming structure that required the parking to be brought into compliance. There are so many facets in the municipal code, whether you're looking at administration, traffic and vehicles, zoning, short-term rentals, repeatedly, you are going to see where it says you have to bring your property into compliance with parking. It's just what we do. When we go back to that 2003 plan we talked about earlier, we are looking out for the safe and efficient functioning of our road system and keeping people safe. That's why you adopt ordinances. You have a plan and you adopt ordinances to make sure everything's running smoothly. The agreement that we have with the DOT further states we shall keep the highway free of encroachments, meaning we have the ability to remove hazardous parking areas encroaching on the highway. For the Wisconsin Department of Transportation, I have the statutes there, but I also just include something on the website defining encroachments. It says the highway right-of-way is the area needed for traffic lanes, shoulders, ditches, and errant vehicle recovery. As I said, as of yet, we have not opted to remove the White's asphalt. or sorry, the asphalt in front of the White's property in the public, the platted right away of Bay Shore Drive. Just some final thoughts. Whether the parking area parallel to Highway 42 is on-site, off-site, non-conforming, or somehow permitted, which we do not believe it was, it constitutes a nuisance. And here we go, here's another chapter in the municipal code. It's a nuisance under chapter 30, nuisances. Section 30.2 defines a public nuisance as a public nuisance means a thing, act, occupation, condition, or use of the property which shall continue for such length of time as to unlawfully and substantially interfere with, obstruct, or tend to obstruct or render dangerous for passage any street, alley, navigable body of water, or other public way, or the use of public property. I cite a case here, court case here, that says, when a non-conforming use constitutes a public non-conforming use of the driveway, it's actually illegal, but Mr. Berg was arguing it was a non-conforming use, but it's illegal. So if you have a non-conforming use that constitutes a public nuisance, a community may prohibit the use, regardless of its duration or legal status as a non-conforming. So we, like I said, as the DOT agreement gives us the authority, under the nuisance code, we also have the authority to go in there and take that parking away. We don't want to do that. We want to work with Mr. White. He was very cooperative until the attorneys got involved, to be honest with you. I believe that that driveway can be brought into compliance. There's a lot of room over there. But there's so many sections of the code that just says you can't have it. You can't just look at chapter 18 and say it. I mean, there's so many other things that come into play here. Chapter 18 was cited in the beginning because he had applied for a license under chapter 18. We said, hey, I can't give you a license because of this. But there's so many other things that impact this property. You've seen the GIS aerial photography of a truck extending past the White's property line and into the public road right away. That is in the photos I gave you. And we received a recent photo of guests parking along the road, blocking the ability to allegedly safely pull over for emergency vehicles. I'd also like to add the Wisconsin Department of Transportation conducts traffic counts along the highways. There's not data available for this specific area, but we know just north of Sister Bay along Highway 42, the most recent count was done in 2022 and showed an average daily count of 4,100 vehicles. So at that time, you potentially have 4,100 vehicles going past that property. Downtown Sister Bay has a higher count, but the data is not close enough to the White's property that we can actually use it. But we do know further down at the intersection of 42 and 57, there was 9,100 vehicles. It's safe to assume anywhere between 4,100 and 9,100 maybe is what's going past that property. A state highway is designed to carry traffic efficiently, so any encroachments or possible obstructions can greatly impact passing traffic. According to Wisconsin's crash data from April 2007, which is the first aerial photo we have showing that driveway, until now, there have been 7 accidents just between Scandia Road and Hill Road, just along Highway 42, which is the stretch where this property is located. Other thoughts as the aerial photos reveal, in the past, a substantial amount of trees were removed on this property, which is a violation of chapter 66, furthering the violations on this property. And again, the code's saying if there's violations out there, don't issue a license. You know, we don't want to put a hammer on somebody. But let's face it, there's a lot of problems with this property. And we're just trying to get some compliance on the parking. The Whites could have applied for a variance for that portion of the parking located on their property. They did not. Instead, they chose the appeal road. Attorney Burton claims requiring the parking to meet code would result in White having to remove costly landscaping he just completed. But keep in mind, that email that was in the packet that I read to you earlier, when I emailed Mr. White in 2023, I explained, and he was saying he was going to install his landscaping I had told him, you know, I've not inspected your property yet. There could be code changes that impact the property. He opted to go ahead and put the landscaping in anyway. He may have done some before that, but he was referencing he was going to put landscaping in at that time. In conclusion, you are here to determine if the zoning administrator erred in her determination that White's parking did not meet code and had to be brought into compliance before a short-term rental license could be issued. I argue the parking does not meet code, does not meet the requirements of the code in effect at the time the Whites applied for the license. And as explained, the parking situation is not a legal non-conforming use, as Mr. Berg had argued. Instead, it's a violation. The municipal code states a license cannot be issued to someone if there are violations on their property. And furthermore, specific to the parking parallel to the highway, the village of Sister Bay has the authority to regulate Highway 42 and prohibit encroachments. With that, I respectfully urge you to deny the appeal submitted by Attorney Berg on behalf of the Whites. That concludes my testimony or my presentation.
Okay, this portion will be the attorneys to question the village administrator.
Really, your view is the,
Louder, please.
sorry, is the turnaround portion of the White's driveway on street or off street parking?
Based on the surveys that are submitted, it is not on Mr. White's platted lot, so we would use that as off-street, on street, sorry. It is not on his
Even
platted
though
lot.
it's not on the actual street.
It is not on the platted lot, it is on the platted roadway.
Is it your interpretation of the code that people cannot park at the end of their own driveway?
That is not my interpretation. And I've never said that. And that's why I said the code says you have to have room to make sure you have legal stalls to make sure you can accommodate people on there. But we know people park at the end of the driveway. And I'm guessing that's probably why that requirement, that old requirement from way back when was removed, because people do park at the end of the driveway.
So the Whites and their guests can park on the turnaround. And they
Nope,
can
that-
park at the end of their driveway.
No, because the end of their driveway happens to be in the public right of way. He does not,
So your
As
position is that people cannot park at the end of their driveway if the end of their driveway happens to be in the unused portion of the right of way. That is your position.
my position is if they have adequate room on their lot to accommodate code compliant parking stalls, we do not lease them or prohibit them from having the tail end hang into the public right of way. But they cannot use what is in the public right of way as one of their code compliant stalls that they are required to have.
So to be
Their
clear,
stalls
they,
must be out of the public right of way.
they can park at the end of their driveway in the public right of way, the unused portion. Their guests can. Their guests can also park in the turnaround,
No,
so they can't.
they cannot park in the turnaround because the turnaround is not on Mr. White's platted lot. It is on the public road, which the village has the
Well,
jurisdiction.
that's also true of the end of the driveway that's in the right of way. So that's different or the same? I'm trying to understand.
They cannot use the parking that is in the public right of way as code compliant stall, as their code compliant stalls.
So part of the end of their driveway is in the public right of way as you define it, and your position is they can't park at the end of the driveway.
No, what I'm telling you is they cannot use that to be considered their code compliant stall.
But they can park.
You have to have code compliant stalls on your property.
I'm just trying to ask, I just wonder if they can park there.
When
When they use the property, can they park at the end of their own driveway?
they can park at the end of their own driveway, you said when they use their property, they can park at the end of their own driveway. But when they're gonna use it as a short-term rental, they have to make sure they have code compliant stalls.
Can
Mr.
their-
White has to make sure he has room for a code compliant stall.
Can
If
their,
his tail end hangs over the right of way,
can their guests, while they're there, park at the end of the driveway?
does he have code compliant stalls?
That's not my question. My question is, can they park at the end of their driveway when their guests are there?
They could park in a code compliant stall.
So they
If
can't
they,
park.
if they
at the
had a
end of their
code,
driveway.
if they had a code compliant stall, but they don't have code compliant stall.
So the answer is no, they can't park at the end of their driveway.
They can park wherever.
So they can park at the end.
I'm not saying legally. They can park
I
wherever.
just
They
wanna,
might get told.
I just wanna know the answer. I just don't know what your position is. I'm honestly trying to understand.
I thought you heard my presentation. Okay, so what happens is they have a platted lot and all their code compliant stalls have to be on that platted lot. They can't use anything in the public right of way as their required stalls. They can, as we know, people can pull over, occasionally go to garage sale, you park in a right of way, you park at the end of somebody's driveway, you can do that. Our code doesn't prohibit you from doing that. But if you wanna have a home or a short-term rental, you have to have space on your property for your code compliant lots.
Right, so these are two different issues. The issue first is, what does your driveway have to be to get a license? That's one issue. The second issue is, how can they use it day to day? So what I'm trying to understand is, they're renters, when they're there, can they park, in your view, at the end of the driveway? Just yes or no, can they or not?
In public right of way on their property,
On their property, on their driveway, but it's in the unused portion of the public way. Can their guests park in that space?
our code does not prohibit somebody from having the tail end of their vehicle hanging into the right of way at this point.
So
They
they
have
can,
to-
so they can park at the
If they have room for their lots to show that they have and have the intention to, and can make sure they park on their own lot. We do realize that vehicles hang over, we do allow them to do that.
So likewise, they can park in the turnaround, which is the same back situation as the end of their driveway. It happens to be in public right of way, but it's the unused portion, so they can park there too, because it's the same.
They cannot park there overnight. And the whites cannot claim that as their code compliant parking, because it's not on their property.
But they can park.
They can park there, somebody wants to run in, get a loaf of bread, drop off some, go over, park there, but they can do that on any place they want. They cannot, per the code, claim that as their parking stalls, the 2 to 4 they're required, they cannot claim that space as theirs because it's not on their property. They cannot park there overnight because the code does not allow them to park there from 2 to 7 AM. But sure, they can pull across the street, run in and get a loaf of bread, drop off some flowers.
So is
That's
that,
fine.
are you clarifying the answer as to the end of their driveway too? So your position is they can't park at the end of their driveway more than just to run in and grab a loaf of bread?
I did not say that.
Well, so what's the answer as to the end of their driveway? Can they park there?
They have, what we require them to do is you have to have 2 to 4 parking stalls entirely on your property. They have to be 10 feet wide by 19 feet deep. So if you have 19 feet of depth on your driveway, we're gonna say you have enough room, you meet the code. Now, let's say some of their car pulls stretches beyond that. We're okay with that, because you know what? They have the code compliant parking they need.
Again, two separate issues. What parking they have to have and where they can park it when they can park. So again, I'm just trying to clarify your position. Can they park overnight at the end of their driveway in the portion that's in the unused right of way?
Technically, no, we could go out there and have it towed. Because we do not.
Can't park overnight. So that's true, not just of the lights.
Actually, I'm sorry. You're talking in their driveway.
Right.
Not the roundabout or the asphalt area,
Well, the roundabout, I think, is part of their driveway, but right now I'm just talking about the perpendicular.
the extended part that sticks out. We do not have code that prevents somebody's tail end from extending into the right of way between the hours of 2 to 7 AM.
So they can park at the end of their driveway, 2 to 7. Even if the car is in the unused portion.
Driveway, but they cannot claim anything in that right of way as their required parking stalls. That is correct.
But they can park overnight at the end of their driveway.
As long as the entire vehicle is not sitting along the road in the right of way, we would allow that. So if your tail end is sitting in there, we do allow that, sure. Now, can they
What if-
go parallel along the road, along Highway 42? No, they cannot. So that would be in the right of way.
The unused portion of the right of way along 42 is quite wide, quite deep, goes in about 10 to 15 feet up into their driveway. So if they have a small car at the end of their driveway, and the majority of it, most of the car is in the unused portion of the right of way, but it's in their driveway, it's not on the shoulder. Is that allowed or not overnight?
Do they have code compliant parking?
It's not my question. My question is, can they park
Then
their
I
car
would
there?
say no, because they don't have code compliant parking.
So you say no.
We say, our rules say, you have to, I think your 3 minutes are up, by the way. Our code says you have to have code compliant parking on your property, provided you have that. If you extend over, we're okay with that, because we know if you have to move, you can do it. You can get in it, you can be in the code compliant parking.
So the answer is yes, they can park overnight at the end of their.
You can, my answer is according to the traffic, chapter 58, you cannot park overnight along Highway 42 or other village streets along.
I'm gonna stop trying. I still don't understand what the position is here. It seems to be that you can park at the end of your driveway overnight. Again, I'm not totally clear what Julie's position is here. But what I want to emphasize is the one thing that none of you heard is any evidence that their driveway has ever been a problem, a real problem. It's been there for 50 years. We have evidence of that from the prior owner. In fact, Julie concedes that based on her search of the records, it was built sometime between 1977 and 2007, so it could have been built in the 70s, which is what the evidence that we submitted says. So that's the evidence before this body, is that it was built in the 70s. It's been there for 50 years. The reason her search of the records didn't find a permit for the driveway is because it's not the village that permits the driveway. It's the Department of Transportation, because it's a state trunk highway. And I provided you the manual that says there are just situations where the property is so old and the driveway is so old that we can't find the permit. And what do we do in those situations? And the Department of Transportation says, we leave the driveway in place and we don't make you take it out, we don't make you remove it, and we treat it as a legal non-conforming use unless there's a safety problem. Again, there's no evidence has been presented that there is a safety problem. So this is an approved driveway by the Department of Transportation. They are allowed to use it under the village's own ordinances. It says you can park on driveways. I think that's pretty clear. And so for those reasons and the reasons that we already stated, I think you should remove the condition and allow them to use their driveway. Thank you.
Am I reading?
Do either of the board members have any questions for the village administrator?
No, I don't believe I do.
Why has it become an issue this time and last year it wasn't?
Because the village, the trustees changed the code. So they said instead of just having them submit a parking plan, this time they actually have to submit dimensions and show us exactly where it is and what size it is to make sure it can actually fit on the lot.
And that right of way, so nobody can use the right of way, because I went down Maple Drive and I looked at the GIS plat where the right of way is like. There's hardly, I mean, there's lots of places down there that don't have enough parking for their stuff. I think we need to work with him. I think we could get 2 cars in there. I don't know. I just don't understand why all of a sudden, I know you said you changed the rules or the laws. I don't.
So he has enough depth. That stall he has right now is deep enough to have the vehicle out of the right of way. And it's wide enough for one. I think he's like within like 6 inches or something like that. But he only has enough room for one. It's only wide enough for one. So if he had made that 10 feet wider, it would have been wide enough for 2. But the problem is it was too close to the property line.
Okay, and it's
So
not
he-
long enough?
It's deep enough, from road to house, it is deep enough.
But I meant for two vehicles. I
It's
drove
not
by.
wide enough for two, right? So he would have
But
had
you
to,
can't park end to end.
no, he doesn't have to move that. You saw in those air photos, there's the one where the truck is hanging almost out into the traffic.
Yeah, that was a big.
It's a pickup truck, but. So he has the width, he has the depth and the width for one.
Okay,
He has the depth for a second, just not the width. He'd have to add 10 more feet.
okay.
But the issue is, he's too close to the property line. As you know, people can go for a variance for that. We just had a variance case on that. But he never applied for it. What, if I was Mr. White's attorney, I probably would have advised him to try and get a variance on it, you know? Because then he only had to widen it 10 more feet towards the center of the lot. And then he would have had the 2 that was required. Now, there's still the issue of what's in the public right of way, but that's not on his property.
But that's an issue because we did do a variance for that last one, but that second vehicle, wasn't it parked like this?
Yes, because he had more depth.
Okay.
He was able to, he had the
More,
40
yeah.
feet
That's
before he came to the public
Yeah.
right of way. So he had the depth, he didn't have the width. In
Okay.
this case, Mr. White has the depth.
Depth.
He could expand it another 10 feet to get the width he needs for the 2. But the problem here is he's up to the property line, so he'd have to get a variance to stay up to that property line. And you guys would have to decide, is there a hardship, you know, what, you'd have to look at all the site conditions and all that stuff to decide. Is there a reason why he has to stay up to the property line, or why can't he bring it into compliance? That's up to you, that's a whole separate thing. They have not applied for a variance here, right? So, but yeah, if he would add another 10 feet to the south, if he had a variance, added 10 feet to the south, he could legally have 2 stalls on that property, the minimum 2 he needs. They just haven't gone that route. And then you still have that issue of all that parking in the public right of way.
Can I say a couple things in response?
Yeah.
So they don't need a variance, not a variance case, because it's a legal non-conforming use. It's been in place forever. And under the village's own ordinances, it says, if it's been in place forever and the zoning code changes, you don't have to get rid of it. So it didn't make any sense to apply for a variance because it's already a legal non-conforming use. I also just want to point out the practical problems of rebuilding the driveway. So I think the satellite picture that Julie provided, this is Appendix 3M. If you just look at it, it's going to illustrate the problem. Okay, so she says, well, there's enough depth in the current stall to fit a car, maybe a small car. But if you look at the picture, the truck, you know, even if it pulls all the way forward in that driveway, it's still in the red section, the back of the building, which is in the right of way. And there's this 10-foot setback. So if they have to rip out the driveway and replace it, where are they going to put it? There's one option is literally right in front of the house, rip out the sidewalk. That's barely going to be deep enough to fit a car. And if you have to fit 2 cars like that, that's basically the whole front of the property is going to be pavement. And then if you look at the left side of the property, at the front of the turnaround is a utility pole. So unless the utility removes the pole, they can't practically build a driveway on the other side of the utility pole. And so there's just, it's a very challenging problem. And, you know, currently they have 3 spaces, at least. They can fit 1 car in the perpendicular section. They can fit 2 cars in that turnaround very comfortably. As the pictures that I submitted show, I had a minivan in just the front half of it very easily. And that's behind a utility pole, so there's not any traffic problem, safety problem, anything.
Guys, I bet
And
you
the
look at the
last
facts.
point I would just like to make is, if you think a variance is necessary, again, I don't think a variance is necessary because this is a legal non-conforming use, but if it is necessary, as I said in my remarks, we are asking for one and you could grant one. I think that would be the right thing to do, just given the situation, given the practicalities of this. If you think that's necessary, that's a simple way to resolve.
He spoke, so I want to speak.
Oh, wait, let me respond to that. Mr. Berg, while while a variance may be a direct and appropriate method to resolve this issue, I have to say this board does not have the authority at this meeting to do that, because they have not noticed this meeting as a request for variance, and any member of the public would have a right to come in and contest a variance that was requested, but they have not been told. Has been no notice that there was the possibility of granting a variance by this board, and while this is the correct board, we are not noticed such that this board could grant a variance tonight.
Fair enough. I'm just trying to avoid wasting everybody's time. Because
Understand?
that hearing will be exactly what we're doing now. But again, I don't think a variance is necessary because I think it's a legal non-conforming use under state law, under the village's own ordinances, under the constitutional rule. But, you know, if you decide otherwise, we need to seek a variance, we can do that and have this whole hearing again in 2 weeks. On all the same evidence.
Okay, so I'd like the opportunity to talk for 10 minutes too. So, you guys, I urge you to not just listen to hearsay, I urge you to look at the documentation and the facts. Mr. Berg is saying there's not enough room to put that car in front of the house, and oh, that truck, you know, there's no way it could move up there. The zoning code says how deep something has to be. That's based on engineering and science, public works engineers, right? They say you need X amount of depth. Based on his survey, he has that. Yeah, in that picture, that truck didn't pull up all the way. It hung out pretty far, right? But you can get vehicles in that between the right of way and the house. He's got the room to, I mean, he's like 6 inches off, I think. But so when they're telling you, no, we don't have the room, blah, 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 that's not true, you guys. They have the depth and it's on the survey and you can see the survey. Don't listen to hearsay. Look at facts in the code, facts on the survey, facts in the email. Because I think you're trying to be misled. No, you spoke and we're done. We were told we to get one rebuttal and you are done.
I
We're
think
done.
you should look at
We're done.
the pictures of the property,
So,
which show that there's a staircase in front of the house. So although it might look on the survey like there's enough room from the edge of the right of way to the front of the house, there's a staircase into the house. Obviously, you can't build a driveway on top of the staircase. So what are they
if
supposed
he
to
was
do?
required
Okay,
to
you're
tear
up.
up,
You're over your time.
if he was required to put the entire thing in front of the house, we'd probably need a variance from the staircase, or the staircase would have to be relocated or something to that. Now, he could put that entire driveway to the south. There's nothing that prevents him from doing that. As a matter of fact, when you look at those air photos I gave you, you can see where they cleared out the entire south side of their lawn. That was wooded and beautiful. At one time, you could use the argument, you can't put a driveway there, it's completely wooded. But either Mr. White or the previous owner went in, obliterated it, cleared it out. It is the perfect spot for a driveway and a garage. So don't give me that. There is room on that lot for a code compliant driveway garage lot. I was trying to give them a break saying, hey, if they want to keep it in that corner, you know, if they would have got a variance on that side and just widened it 10 feet, they could have made the 2 code compliant stalls, is my point. And then Mr. Berger saying, no, we don't have enough depth. Yeah, you do. Pull out a survey, measure it. You do. That was my point on that.
I have a question for you. So is it, the right of way, is it different for commercial or business use versus residential use?
No, we don't allow anyone to park overnight in the right of way.
Okay.
It says, when it says along, it's talking, he can't pull over along the road and just park his vehicle along the street. We don't allow that. And neither does law enforcement.
I'm just stuck because I see where the edge of the highway is and where his driveway is, and I know it's in the right of way, but it's on his property, just like it is for Ace Hardware and Husby's. They are in the right of way and people park there overnight.
So they're not supposed to. However, we do have an exception in certain areas in downtown. So if you're by the bars, we don't want drunk people driving drunk. So if you're by the bars, we do have exceptions where they can stay overnight on the road.
But this, I don't, and this is, I don't believe that his driveway, I know it's in the right of way, but it is not in the road. People are able to park next to his vehicles that are in there. They may get trapped in, but that's his problem.
It's not even on his property though. We don't allow that, every single short-term rental application we had, every single one of them, except Mr. White, has modified their driveway, added onto it, cut it back, etc. So their parking is on their property.
I understand.
It's, that's your property, that's my property, and if ambulance is coming, I wanna pull over, and I don't wanna have to worry about hitting the pole or something. That is the public's property. It is their right to have access on it and a safe, efficient highway.
So that's not entirely true.
You're done.
I would like to respond to that if I can.
We already covered it. How long is this gonna, I mean, I thought he got rebuttal, I thought I got to answer questions.
Well, when you've had your turn, he's had his turn, so we're just about over, we're in the portion now where my board members are asking the question and you are responding. If there's a question for the attorneys, then there will be a response.
Can I have a chance to respond to that? Because what she said is not accurate.
Well, I've alleged a lot of stuff you said wasn't accurate. and
I'm learning, I mean, I'm having troubles understanding it, but go ahead.
She said the driveway is not on their property. That is not true. There is a rule of law, property law in Wisconsin, that the adjacent owner, this is what I talked about in my remarks, the abutting owner owns the property to the center of the street. Even when the conveyance and the original survey shows that it ends at the highway. And the reason for that is if the road ever were discontinued, it's not gonna be discontinued, but if it ever were discontinued, the land goes back to the adjacent property. There's a statute that deals with that. And so that is the rule of law. They own the land under the road all the way to the center of the street. And one of the corollaries to that is they have the right to use that land for any purpose that doesn't interfere with the right of way. And so, again, they have a lawful driveway. They got approval from DOT.
No, they didn't.
It's not, well, there's no evidence that they did, and it's been in place for 50
That's what
years.
They did.
And the way DOT treats old driveways like that is as a legal, very important legal non-conforming use. So it's a legal driveway per the DOT's own manual.
I would like to comment on that because, of course, you said that before, but I do disagree with your interpretation of that case in that law, but regardless of who owns that, the DOT gave the village the right to control that road and dictate whether you can park overnight on there, have encroachments, etc. So it doesn't matter what that law says. It doesn't matter what the DOT may or may have not have done. In 2018, they gave the rights to the village to control what happens in that public right of way.
Control parking on those streets. I certainly don't disagree that the village can control parking on the street, give people parking tickets if they park on the existing road. But I don't think that agreement allows the village to tell people they can't park on their own driveways that DOT has authorized.
It's
them
not
to
the
have.
driveway because it's on public property.
Okay, we're going to end this portion. Once again, Patricia. Any questions? This is the last time you can ask questions.
Would this be resolved if a variance were applied for and given? And then things would be over? And is there something standing in the way of that happening?
So I can answer that. They could apply for, if their intent, no, we don't know their intention. If their intention was to take that section along the north property line and widen that another 10 feet and apply for a variance for that, it'd be up to the board, but they could do that and they'd have 2 legal parking stalls. Can they apply for a variance in the right of way? No. It's not on their platted lot. They'd have, we'd say, show us your deed. You don't own that property. I know what he's saying, but his was, that interpretation, that case was regarding a plating issue, land division plating, that's what that case he references is what is about. So it was can't apply to everything, it's talking about something totally different, but, we would not allow him to apply for a variance on for something that is not on his platted lot. No, I wouldn't allow you to apply for a variance for something on your neighbor's property. So we would not allow him to apply for the, parking on the platted roadway. And when I say roadway, I mean 66-foot wide road that was platted in 1910. But yeah, he could apply for a variance for the other section if he just wanted to make it wider. He could apply for a variance for, I just want one stall. I just want it up to the property line. He could do that. I think,
Okay. Anything else, Patricia?
I'm just wondering, so it's standing in the way of that being resolved? It seems like it's a,
they never
Logical.
applied, that's up to them. They've never pursued that. That was their fault.
okay, thank you.
You want me to address that? You want me to address that?
Yeah. Why didn't they apply?
Because in their position, their position is they don't need to. It's a legal non-conforming use under the village's own ordinances, under state law, and under the constitutional rule. So they don't need a variance for it because they already have authorization to continue it as a legal non-conforming use. Again, it's been there for 50 years. In the well-established rule of property law is if your driveway or your home is in place before the zoning code changes, you don't have to pick it up and move it over 10 feet to comply with the new zoning code. So they don't need a variance because it's a legal non-conforming. Again, but that said, they are just looking for the simplest way to go ahead with their lives and keep using their property. So if you all think the simplest way to do this is to apply for and get a variance, we'll do that. But again, I don't want to waste everybody's time. So if what Julie says is correct and you can never grant a variance for this sort of thing, we're not going to waste your time and do that and come up here 2 weeks. So, I would appreciate some clarity about that from you all so that I'm not wasting your time.
Well, and I'm thinking,
We're not into that yet. Do
I
you have
can't
any
talk to
more
you?
questions?
no more questions.
Okay. And, that's fine.
6:27. 6:27.
Okay. And at 6:27, I am going to close the public portion of this hearing. And we will now commence into the decision discussion portion. Okay. We've heard a lot of information from both sides, and all of it really deals with parking places with two vehicles. It seems that there's been discussion that a variance might be the answer to get this thing going and out of the area of research and presenting perspective. So I'm going to make a motion that the decision of this body would be that we will, how would we would just do that.
Well, I think, Mr. Chairman, you were talking about modifying the
Yeah.
existing order
How do I say that?
to allow for the parking as and if granted through a variance.
Through a variance, yes. So, and so we have on our decision making, we have the review of the determination is 1, affirmed as presented. 2, reversed in the following respects. Or 3, modified as follows. So at all the discussion that I've heard today, it seems that a way of getting this to become a successful conclusion would be for us to make our decision as a modification with the proper word, and towards the end of a variant request being submitted, and a hearing would be held for that variant. And if granted, that would resolve the problem and allow the petitioners to move on and conduct their business.
Okay, so what verbiage do you want, Randy?
No, I'm just talking in generality there before we get.
See what they have to say before we work out some specific language. I think the chairman has gotten the general message across.
Yeah, I think,
Well, I have to get with this, my two board members here. This is what I'm proposing.
apply for a variance and
Well, so our decision would be a modification, and the modification would be the recommendation to apply for a variance to clear up that cloudy area and allow for two vehicles to be parked in that particular lot,
Yeah,
okay?
I think it's the easiest way for everybody to get this resolved.
Yeah, but we can't do it today, it has
No.
to be a separate,
I know, yeah.
yeah.
I'd love to say you could grant a variance tonight, because you're the right people to do it.
Well,
But it's not good to resolve one problem by creating another.
yeah,
Now, there's,
legal.
there can, because there's legal notifications
so many days.
that have to do that, both by putting it in a newspaper and by a certain timeline. So what's the quickest, that possibly could be, so
15 days, right? Or is it 10?
15,
I think-
okay, our earliest would be 15 days, so in essence,
Because you have to have one publication.
But no, two.
No, it has to be two,
Publications.
the last, two and the last, it has to be 10 days before your hearing.
Yeah.
okay, so we're looking at a period, say, in the week of the third week from now,
Yeah.
that would be.
We can look at the calendar and figure it out, what days would work for you guys, as long as everyone's here.
You'd have to wait and see when they get it in, and then how that fits into the publication deadlines, because it has to be.
Okay, so, well,
Sometimes, I mean,
let's work for 3 weeks, the third week from now, to have that process.
Can I ask, is the board planning to issue a written decision or give its reasons? I mean, what we asked for is a reversal and a removal of the condition. And it seems that's being denied. So I'd like,
We're not reversing and we're not affirming.
so I would like to know the reasons why you're not reversing, because I think that's the right answer here.
Yeah, because you should technically go through this whole form.
Yep.
And go from top to bottom, and fill in the blanks.
Again, our main position is it's a legal non-conforming use. They don't need a variance. So if you're gonna say that's not true, I think we need to know what the reasons for the denial.
and I keep talking,
Well, the Board of Appeals position in the matters where we're dealing with, in this case, the zoning administrators' rulings, which are in question, and we have to make a decision that we concur with her rulings, that based upon the information we have, we concur with her rulings, and then, or we do not concur with her rulings, and then it would be more to your side. You know, how, so we have to be ourselves, after listening to the village administrator and looking at her research, is the question, did she err in doing that? And then are her responses, both written and verbal, as such that we do not concur with it. And if they're listening today to both sides, I have not found anything that would cause me to issue a non-concurrence of what she has presented, that she has erred in what she has done. So. Liz?
I just have a question. If we say either side won or lost, let's say we say Julie's correct, can he then go for a variance then?
You could modify the decision, as I see it, to allow for the permit to be properly granted if a variance as to parking issues is granted. You still need to go through the decision determination. First of all, my recommendation, Mr. Chairman, would be that you take a vote as to whether the board wishes to affirm, reverse, or modify the decision. And then go through and establish some reasons so that that can be part of the decision.
Right. Okay. Okay, I'll make first motion I'll make is that based upon the information that we have been presented with, both verbally and electronically, the decision on the review and determination is not affirmed. By not affirmed?
Yeah.
Well, if we affirmed it as presented, then we would be saying that what is there is proper. And so we have the three choices. Maybe we just take the one we want, which was where I was before, modified. So
But he wants to know why, if we pick modified, why we're choosing modified versus affirming or reversing the decision.
well, we can do either one, affirm or reverse, and then it's over here. Then we don't have to worry about anything else.
Except you still have to have reasons for your decision, whichever one you choose here.
Yeah. So the affirm means that the review of determination, which was presented by the attorney and the village president, we are affirming the wording in that. If they allowed the business to reopen, and they said the issue on parking would be resolved here, but still an open issue. So if the open issue hasn't been resolved here, then the parking issue is not resolved. So we would be affirming that document, the words in that document. If we reversed it, then we're saying that the parking issue that's there, that's present, is sufficient. And we do not, we'll go with that. Modified, we're saying that there's enough information that we want to modify that notice of determination so that we believe the parking is there, but we're not sure it's there. And there are some things that aren't fully or need some adjusting by another meeting. And the adjusting where a variance would be utilized to make whole the things that don't fall in line. And so that would be our modification.
More or less, yeah.
So, okay,
Could you start at the very beginning of the form and go right down when, that's
Okay.
probably the best way to do it.
all right, findings of fact, having heard the testimony and considered the evidence presented, the board determines that the facts of this case to be the filing date, August 9th, affidavit of publication, posting on file, hearing date, August 22. The appellant, their name and address would be put into that part, known as Captain's Cottage. Have asked that the existing parking,
Okay, hold on a second. No, you're on B. The property is presently in use as a short-term rental and has
no,
been.
I was, did all I have to put is the names in that first part?
You've got a different form.
Yeah,
Oh.
Janelle revised that.
These words, sorry, holiday, these words are changing. This is again, the first time we have done a hearing of this nature. And so that's why we're fumbling up here is putting good words. Okay. All right, we'll start over. Findings of facts, filing date August 9th, public hearing on file. The date August 22, the appellant is Captain's Cottage, 10775 North Bay Shore Drive, Sister Bay. The property in use is as a short-term rental and has been so used continuously. And we're gonna use the date. You started renting in 2020?
They started running in 2020. It was
Oh, you
previously
2020, sounds good,
Okay, since 2020, okay.
yeah. The appellant proposes the use of the property as a short-term rental, this is nice, better form. All modifications as required in the review decision appealed from. The appellant requested an appeal of the review of decision appeal from, or the appellant requested a review of the decision appealed from.
So you want me to check and appeal the review decision appeal from that one?
Yeah, that's what they requested.
Okay.
I think it's both. The
Oh,
second one too.
Wait.
What we're asking for is a removal of the condition. That they have.
Modification, okay, check both.
okay.
Based on the findings of that, the board concludes that the decision on review of determination is modified as follows. Does the board conclude that?
That should be my motion, Mr. Chairman.
I know, I'm just making sure before I go any further that's where we're at. The petitioner should apply for an variance. Over the dimensions of the existing parking. On the driveway portion, not the portion of the roundabout.
My suggestion, Mr. Chairman, is that it would be a little more clean if we had something to the effect that the condition requiring parking modification in the decision is removed if a variance is obtained as to parking requirements.
Alternative rest is just that it's removed, so that's what I would hope that you would give some clarity on why it's not.
So your motion is gonna be then, the condition requiring parking modifications is modified if a variance is obtained as to the parking requirements.
That condition would be removed
Okay,
if a variance is received.
will be. And then Tom, you wanna make a motion to that effect?
Do we want to, agree?
Well, make that next. One step at a time.
Yeah, make a motion and, we can make a motion on that. Yes,
Okay.
Janelle will read the motion.
Okay. I'm just typing it down. So, motion by Sadler, seconded by somebody, that the conclusions of law with regard to this case shall state that the decision on review of determination is modified as follows. The condition requiring parking modification will be removed if a variance is obtained as to the parking requirements.
Do we have a second?
I'll second.
Okay. Then take a roll call.
Hopefully you want to do a roll call vote today.
Yeah.
Right.
Yeah, aye.
Yes,
Listener
I,
and Sadler.
Okay, next portion is to present reasons based upon the decision of the zoning board of appeals is based upon the following determinations. One, that the information that has been presented by both the appellant's attorney and by the village administrator covers a lot of subject matter and a long period of time. Without balancing the outcome one way or the other. Both the petitioner's attorney and the village administrator have produced thoroughly researched presentations. that each support. Portions of the driveway problems. The board feels that the potential successful conclusion for both sides would be a separate hearing requesting variance to the required parking driveway standard.
You want me to read that back? Now you've got like three separate things, is that right?
Well, we got ABC.
Okay. So for E, that info presented by the appellant's attorney and the village administrator covers a lot of subject matter over a long period of time.
Covered
What was it?
a lot of subject matter
Okay,
or
a long period of time without balancing the outcome one way or the other. That's your first one.
Yeah.
Okay, then the second one is both the attorney and village administrator have provided thorough researched presentation that support portions of both of the driveway problems. That okay?
Yeah.
Okay. The board feels that a potential successful conclusion for both sides of this issue would be for a separate hearing requiring a variance to required
to review
hearing requiring a variance to
review the specifications.
Parking requirements.
Okay, my attorney said to review the parking requirements.
requirements.
He's always that.
Okay.
Like that.
It said to be for a separate hearing requesting a variance to review the parking requirements is justified.
I don't like that you justify.
Oh, not justified, okay.
Then you're prejudging it.
Oh, okay.
There's two members of this board that are gonna be here that haven't heard any of this,
Oh, okay.
or me, let's put it that way.
To review parking requirements, what?
Review the parking requirements.
Review the park, he wants to end it in there.
Okay,
Okay.
Right, Mr. Chairman, my recommendation would be to also address directly why you don't feel it's appropriate to affirm the decision as presented, and why you don't feel it's appropriate to reverse the decision. Should probably give something a little direct in there. I know we're going more than three that are required in the form here, but I think it would be appropriate for the decision document to contain something as to each one of those.
Okay. The board, then
you know, is this for not appropriate to affirm or the other one? Or reverse?
you're still on D. Or you.
Well, could be E and F, but
All right.
Janelle's got a typewriter. She can take it.
Yeah. Okay, so how about if we start with not appropriate to affirm because?
Okay, it was not appropriate to affirm because the information that was presented covers many years. And cannot be confirmed. Or rejected. During this limited meeting.
Not appropriate to reverse because.
Could be the same reason if you choose.
Yeah.
Same?
Yeah, it is a vote.
Okay. Okay, so now you move on to order and determination.
That's this.
Yep. Right here, yep.
Under D.
That, yeah. Oh, yeah, I went there now. Okay, the decision and review of determination is modified, and the village administrator is ordered to prepare the process to hold a future meeting
If a variance is applied for.
right? Sounds good.
Although if a variance is applied for, see that a related hearing is scheduled in this timely fashion as possible. Okay.
And force them to apply for variance.
Hopefully it will. You take a separate,
We want a motion to that effect too, Randy?
It would be good for the board to adopt those reasons.
Okay.
yeah.
Or suggest others.
Patience, we're trying to get this into the computer format, and so when we leave here, that part of it's all done. It can be printed out.
I don't think we'll have a printed version of the decision tonight. But it sounds like you're heading toward having an approved adoption of what the language is. building doesn't even have a printer, does it?
No. Hopefully we get our grant and we can. Or it should be ready in just a little bit.
We're breaking things.
We could do that while we're waiting.
Okay, so. All right, so. Motion by Sadler, second by Wisner, that the conclusions of law shall state that the decision of the zoning board of appeals is based upon the following determinations. A, the information presented by the appellant's attorney and the village attorney covers a lot of, or the village administrator, sorry, covers a lot of subject matter that extends over a long period of time, and no balance is presented, and the outcome is unclear one way or the other. Is that okay?
Yeah.
Okay. The appellant's attorney and the village administrator have provided thoroughly researched data that supports both portions of both of their arguments with respect to the driveway issues that were identified. Is that okay?
Yep.
Okay. The board feels that a potential successful conclusion to this issue for both sides
would be for a separate hearing to be conducted on a request for a variance with respect to the stated parking requirements and issues. Is that okay?
Yes.
Okay, the decision was made not to affirm because the information presented covers a period of many years and cannot be confirmed or rejected during this limited meeting time.
Yes.
Okay, the decision was made not to reverse because the information presented covers many years and cannot be confirmed or rejected during this limited meeting time.
Yes.
Okay. I want to take a roll call vote on that one.
Did somebody make a motion?
Tom did,
Yeah.
Oh,
Okay,
okay,
you had that.
and Pat
Oh,
seconded it.
just wanted to make sure.
Okay, so do a roll call.
Okay, Sadler,
Yes.
Peck, yes, and Wisner.
We had a second just to that motion?
Yeah.
Okay,
All right, so please hear that.
Mr. Chair,
I have, one more motion. I propose that the fee that normally would be required for a variance hearing be waived in this instant because it is a continuation of this meeting tonight. Okay, we have a second.
The fee that they would pay for the variance is waived, is that what you're saying?
Yes. There would be a new fee for every variance, there's a fee to file it that goes with it. And I'm saying that it's really a continuation, they paid a fee for tonight, it's a continuation of the process.
Do we have authority to do that?
that's a good question.
We don't know if I have the authority to do it, but at least I'm doing it now, and then we can be told later that what did I think, messing with town, village's money.
What I suggested, Ms. Wisner, is that that if the chairman wished to do that, he make a motion to that effect for this group, if it wishes to do that, to approve it, and then I'll have to figure out the village administration, whether in fact there is authority to do that. Right now, I can't tell you whether there is.
No, but we're trying. Okay,
Okay, I got that. You wanna take a roll call or just do a regular poll?
all in favor?
Yeah, I'm not opposed.
Okay, I carry it.
Now, Tom, Bjorn had wanted to ask you a question.
yeah, I would just like to state our client would like to ask the board a question quick, if she could.
I can't hear you.
Our client would like to ask the board a question quick, if she could.
Oh, sure,
I didn't want to interrupt.
I can't hear her.
Thanks for this going so long. I'm sure all the attorneys understand this, but just so I personally understand it, I feel like my husband had to leave to go home to watch the kids, but if we apply for a variance, are you saying that we're supposed to apply for one that allows us to keep the driveways as they are and not alter the property? Or are you recommending we apply for a variance to tear out that circle and still repave the whole right side of the yard?
Where you have the one area where you could possibly put 2 vehicles, your driveway, but right now it doesn't fit the standards that are required. And that's where we're asking you to file for a variance for a review of those standards so that you could be eligible for 2 vehicles if the variance was granted. All right, I have a motion for adjournment.
Yes, I move that we adjourn.
Okay.
All in favor?
Aye.
Oh, okay. You're adjourned. Thank you all.
Thank you, Mr. Chairman.
Thank you all.